Namaskar, Dilip Singh. Welcome to my channel, Journey of Constitution of India. On the previous occasion, in part 1 of Right to Equality, I have dealt in detail about the various concepts of the right to equality. Particularly the two concepts which were discussed was the equality before law and the equal protection of the laws. Now in this video, we will proceed further and discuss about the various judgments passed by Supreme Court from the very beginning. Before I go ahead, let me ask you, how did you feel while going through my first video about the right to equality? Please let me know. Please comment in my channel so that I can improve my information level and I can produce in better ways so that it can benefit you in better way. Now, the judgments passed by Supreme Court started from the very first year and are just after few months of the constitution of Supreme Court. And in Chiranjit Lal Chaudhary versus Union of India, the first the constitution bench was there to consider the statute named as Solapur Spinning and Weaving Company Emergency Provision Act 1949. Before I go to that judgment, let me share some information about Justice Kania, who was heading that bench. Justice Kania has the unique distinction of being the first Chief Justice of Federal Court of India, which was working before coming of Supreme Court of India into being. He headed that Federal Court of India since the day of independence, that is 14th August 1947 till 26th January 1950. He is also having the unique distinction of administering oath to our first president, Dr. Rajendra Prasad. Justice Kanya continued as Chief Justice of India, but unfortunately, he died on 6th of November 1951 while he was in office at the age of 61. Now, in the first judgment which I am referring, Chiranjit Lal Chaudhary versus Union of India, with this judgment, I want to club two other judgments also. That is State of Bombay versus FN Balsara and State of West Bengal versus Anwar Ali Sarkar. Why these three judgments are taken together? Because there are various similarities on these three judgments. The first, which that in the Chiranjit Lal Chaudhary judgment and Balsara case, 4 judges were similar. So the concept that flowed, that continued and that was reinforced. In the next judgment, which was a 7 judges bench, the 5 judges were same as they were in the Balsara case. So the concept initiated in Chiranjit Lal Chaudhary case continued and finally developed in proper way by the Supreme Court in Anwar Ali Sarkar case. And these all 3 judgments were passed within a period of almost 1 year. So the entire approach continued and that culminated in the well-formed doctrine of reasonable classification. In Chiranjit Lal case, which the citation is AIR 1951 SC 41, Solapur Spinning and Weaving Company Emergency Provision Act 1950, which was passed by the Union government, was under challenge. The constitutional validity was challenged on ground of legislative competency as well as due to the violation of Article 14, 19 and 31. Under this act, government has dismissed the company agents. It has removed the directors of the company and reduced the value of the shares, and virtually it has taken over the company. So the company, one of the shareholder of the company, Chiranjit Lal, challenged this act before the Supreme Court under Article 32. There were various issues framed, but at this stage we are concerned here only with the issue which was framed to test the constitutional validity under Article 14. Three judges of this bench found that even one person, because the main contention of the petitioner was, by this judgment, by this act, only one company is made as a class, whereas all other similarly placed companies where the mismanagement is there, they have not been touched. So the first question was whether a class can be created for a one person or one corporation. Then the three judges found that, and three judges held that one person or corporation can be as a class, and for the purpose of legislation. So there was no violation of Article 14. Secondly, these three judges also held that there is a strong presumption of the constitutional validity of a legislation, and the petitioner failed to prove that there were other companies similarly situated and his company has been discriminated against those companies. So there is no violation of Article 14. But two judges dissented from the finding of the majority. One judge, Justice Patanjali Sastry, he categorically held that there is a complete violation of Article 14, as there is Company Act, and the petitioner is being denied to avail the protection against the Company Act. By creating this new act, the petitioner has been discriminated. Second point, Justice Patanjali Sastry said that there is no reasonable classification on which this act is based, and there is no rational nexus. So the concept of reasonable classification and rational nexus was propounded by him in this case. He further said that there can be one man class, but that must be based on the reasonable classification. In case of discrimination, he further said that, Justice Patanjali further said that, in case of discrimination, the presumption of validity is not available. The other justice who resented from the judgment from the majority was Justice S.R. Das, and he said that the impugned act is ex facie arbitrary and discriminatory, so in violation of Article 14. Mismanagement, he said, mismanagement can be a basis of classification if it has a reasonable relation with the objective for which it has been made. One interesting fact is that in this case, Chief Justice Kania, he was debutante on this issue. Debutante means he was differing, but he was not dissenting with the majority of the opinion of the majority, and consequently three judges held it that the act is not void, act is valid, and the petition was dismissed. The second judgment, which just came 6 months after the first judgment, that was the FN Balsara case, which has citation of FAIR 1951, Supreme Court 318. In this case, the four judges were same which were in the case of Chiranjit Lal. Only in place of Justice Kania, Justice Vivian Bose was in this bench. This was also a five judges bench. And in this case, Bombay Prohibition Act 1949 was challenged, and particularly Section 39, which permitted the use of foreign liquor on cargo boats, warships, military canteen, and mess, whereas the act itself prohibited the consumption, possession, and sale of the foreign liquor. this section 39 permitted a particular class, so it was challenged on the ground that it is discriminatory of Article 14. However, this act was also challenged on various grounds, including the legislative competency, but here we are concerned only with the challenge on the ground of Article 14. Here again, the judges were a majority, 4 judges were of opinion that this Article 14 is not violative, and he said that there is a reasonable classification, and the military persons are particularly a different, well-defined class, so there is no discrimination at all. It was also held again here that the presumption of constitutional validity is always in favor of the legislature, but it is a rebuttable presumption. If no reasonable classification is there, then of course the law is violative of equality and Article 14. But if there is a well-defined classification, then law is valid. In Chiranjit Lal Chaudhary versus Chiranjit Lal Chaudhary, and in this FN Balsara case, the Supreme Court heavily relied on the concept of equal protection of law as developed in the American jurisprudence by the American Supreme Court. They heavily relied on the judgments also. Even they relied on the various authors who had developed the concept of this protection of laws. So one of the famous thinker was Professor Willis, who said that equal protection of law does not mean that it has no classification at all. It says that it only prevents the class legislation, but it favors reasonable classification. So, on the basis of the jurisprudence, American jurisprudence, it was held that there is no violation of Article 14 in the Balsara case, and military person are well-defined group, and there exists a rational nexus with the objective of the act. So, the petition was this. The third most important judgment in the series in this trilogy is the judgment of Anwar Ali Sarkar case. The citation of Anwar Ali Sarkar case is AIR 1952, Supreme Court 75. And this is very important for many reasons. First, it was the 7 judges bench, and 5 judges were same which were in the FN Balsara case. Here, the act which was challenged was West Bengal Special Courts Act 1950. And let me say one thing, that this was for the first time in this case, the challenge was only on the ground of Article 14. Whereas in the earlier cases, it was challenged on several grounds. But here, the law was tested. The concept which were developed during the earlier 2 judgments were tested and dealt in detail. And here the court relied not only on the American jurisprudence, which were related with the equal protection of laws, but here it also dealt in detail with the equality before law. There is one more thing, that here the respondent was accused of an offense with various other co-accused, and he was tried by a special court constituted under the provision of West Bengal Special Court Act. And particularly Section 3 and Section 5 were challenged here. In Section 3 of the Act permitted the establishment of a special court, and Section 5 empowered the state government to send the trial of the case to a special court. Under this act, the procedure followed was different from the CRPC, which are used for the prosecution of the offences in normal course of action. In this case, 5 judges held that Section 5 subsection 1 of the Act was violative of Article 14 and so void. Four judges held that there is no ground for the state government to avoid the proceeding under criminal procedure code and refer the matter to be tried by the special court, as right to equal protection of law is violated here because a general law is there and the accused were not tried on the under that general law, and a special law was created for their trial. The majority of judges also found that there is no reasonable classification, basis of classification, and there is no reasonable nexus because the act was having only one goal, only one objective in its preamble, that is speedy trial of the matter. So, but there was no classification, of offenses which were to be tried by the special court for speedy trial. There was no rational nexus between the objective to be achieved and the classification was made. So it was found that the act was violative of the equality of right to equality, because they said that the procedural law is also covered under the ambit of Article 14, because this was one of the plea that the Act deals only with the procedure of the case and it was not the substantive law. But court especially emphasized that even procedural law is covered under the Article 14. Here again a situation arose that Chief Justice Patanjali dissented from the majority and held that Section 5 is not void or unconstitutional. In this judgment of Anwar Ali Sarkar, the classic nexus got fully developed and the concept developed as intelligible differentia and rational nexus got reinforced and settled. So these three cases which I dealt with, which started with the concept of reasonable classification and laid down the foundation of reasonable classification doctrine, got fully developed and established by the judgment of Anwar Ali Sarkar. I think and I hope that you feel better after this journey of evolution of Article 14 and doctrine of reasonable classification. Now, seeing this journey, you would be agreeing with me that law is as live as mind of judge on that day, and it develops is accordingly with the time and requirement of the time. In my next video, I'll take you to a further journey, because the other milestone of the development of Article 14 is the judgment delivered by Constitution Bench of Supreme Court in Ram Kishan Dalmia versus Justice Tendolkar, where the same concept continued, the same doctrine of reasonable classification continued, and further it was evolved, and different statutes were classified to suit this doctrine of reasonable classification. In this constitutional journey, the next of Article 14 next turning point came in the year 1973, after 22 years of the reasonable classification doctrine, and in the case of E.M. Royappa versus State of Tamil Nadu. In my next video, we will be discussing with the judgments who came with the time, and the new concept was developed, new angles were formed to see the right of equality. I hope this journey was very helpful for you to understand the development of the law. This journey is very this, this journey is very interesting, as Parliament, has repeatedly tried to curtail the scope and vigor of Article 14 in order to carry out the welfare program, whereas at the same time judiciary tried its best to keep the guaranteed fundamental rights intact as far as possible. Hope you feel different after watching this video and development of and evolution of right to equality. In the next session, I'll welcome you with the new judgments and new concepts. Thank you very much for watching this video. Have a nice time. Take care of yourself and your family in the difficult hour of this lockdown due to coronavirus pandemic. Thank you very much. Namaskar.